Okay, good morning. Welcome back. Thanks for joining us. Today's seminar on navigating the assessment process and evaluating adult incapacity, diminished capacity, and regained capacity. This is a subject that sits at the intersection of psychology, law, and human dignity. At its core, it's about balancing two vital principles: the protection of vulnerable adults and the preservation of their autonomy. It's also about recognizing capacity isn't always a fixed state. Sometimes it's diminished, and sometimes it's regained. And the process of assessing and determining that requires both careful clinical evaluation and thoughtful judicial decision-making. We're fortunate to have two distinguished panelists here, Dr. Syretta James and Judge Maurice Ross. Judge Ross is going to speak first. Just a little bio. Judge Ross was appointed to the Superior Court of the District of Columbia in 2001 by President George H.W. Bush. Judge Ross was born and raised in Washington, D.C., where he graduated from St. Francis Xavier High School and St. John's College High School. Judge Ross received a Bachelor's of Art in History from Yale College in 1983 and a law degree from Harvard in 1986. Judge Ross has, during his 24 years as a judge on Superior Court, he's presided over the calendars on the civil, criminal, family, and probate divisions. Judge Maurice Ross currently sits in his second stint on the probate division, where he makes determinations of capacity based on the evidence presented. Today we'll focus on the legal perspective, specifically how the courts use the capacity information presented in filings and during hearings, and he will discuss the initial guardianship hearings and hearings post-appointment where modification and/or termination may be requested. So, Judge Ross.
Thank you. Good morning. I just want to make a few points about the Guardianship Act. You know, recently we've had lots of talk in the country about kings, presidents, and judges. And people come in and think, well, you're a judge. It's like TV. You can do whatever you want. And I try to disabuse people of that notion by telling them, no, if it was TV, you'd be looking at Denzel Washington instead of me. But it's a lot more serious. And what I try to tell people is we have boundaries. And in the guardianship area, we have a comprehensive statute that lays out many of the issues we have to address in the probate court. The Guardianship Act provides that the court in an intervention proceeding, which is a proceeding for a protected person, if it's for their health and well-being, it's a guardianship proceeding. If it's their assets and finances, a conservatorship proceeding. The court may, and it's discretionary, appoint a guardian for an incapacitated individual if the court is satisfied that the appointment is necessary to protect the continuing care and supervision of the individual. And likewise, the court may appoint a conservator if the court determines that the appointment is necessary for the support of an incapacitated individual or to protect the property of such a person. And then the statute defines what incapacity is. An adult whose ability to receive and evaluate information effectively or to communicate decisions is impaired to such an extent that he or she lacks the capacity to manage all or some of his or her financial resources or to meet all or some of the essential requirements for his or her physical health, safety, habitation, or therapeutic needs without court-appointed assistance or the appointment of a conservator or guardian. Now, the Guardianship Act does not apply to minors. So, and we constantly have the problem of people confusing guardianship with child custody. Not the same thing. The code also defines what's meant by the terms manage financial resources and meet essential requirements for physical health and safety. And the code states that a person is able to manage his or her financial resources if he or she can take those actions necessary to obtain, administer, and dispose of real and personal property, intangible property, business property, benefits, and income. An individual is able to meet essential physical and safety needs if he or she can take those actions necessary to provide for health care, food, shelter, clothing, personal hygiene, or other care without which serious physical injury or illness is likely, which is more likely than not to occur. As our previous speaker said, a protective proceeding is quite intrusive. And the person who is petitioning to have someone placed in a guardianship or conservatorship has the burden of proof, and they have to prove it by clear and convincing evidence, a pretty high standard, not beyond a reasonable doubt, but much higher than just more likely than not. And you can't prevail in a guardianship or conservatorship proceeding by merely demonstrating that the subject of the proceeding has a physical or mental illness. Indeed, such proof by itself would be insufficient. Lots of people have abilities, they have disabilities, but it can be a combination of factors. The court is not empowered to impose a fiduciary on a subject who does not need one. Our prior speaker talked about the least restrictive alternative. So do you really need a guardian or a conservator? And I should point out in this regard that even though people are maybe found incapacitated by the court still has to respect their wishes as best we can. And recently there was a Court of Appeals opinion to reemphasize that there has to be substantial good cause for discounting or disregarding the wishes of the subject of the proceeding. The test for imposing a court-appointed fiduciary is proof that the subject cannot take those actions enumerated in the code in order to provide for himself or herself or to protect himself or herself. And the Act also provides that finding an individual is incapacitated does not constitute a finding of legal incompetence. So many times on our other side of the probate, on the will and trust side, people come in and say, well, the person didn't have the legal competence to make a will or enter into a contract simply because there was a guardianship or a conservatorship. And it's like, not necessarily. So just quickly in winding up and turning it over to Dr. James. So as judges, how do we make that decision that a person's incapacitated? Well, here in DC, we have a lot of resources. If we're talking about in a 90-day emergency guardianship, the petitioner has to have 2 certifications of incapacity by 2 licensed medical professionals. The only exception to that is when we have 21-day emergency guardianships where the hospitals say, we have someone, we don't even know who it is. The person doesn't know who he or she is. They've been in a horrific accident. They need medical care. We don't have a decision maker. I contrast that to many times families come in and they want to be the emergency guardian. And they say the person has dementia, the person has a stroke. And I sit in chambers and I'm like, okay, where is the person? Are they in DC? Who are you? And then for the permanent guardianship petitions, by statute, an examiner and a visitor are to be appointed. The examiner focuses on evaluating the person. The visitor, in my experience, is going to be focused more on the home environment, the family, the relatives, their assets. But we have to consider all that. If it's a contested proceeding, we look at for expert testimony, medical doctor, examiner, visitor, licensed social worker, look at medical records, observations of family and friends. Most of our probate proceedings are remote. I don't know about the other judges, but when we're going to have a contested competency case or capacity case, I really like it to be in person so I can actually see the person. I can see how they walk, how they carry themselves. I'll usually ask a few basic questions. Age. I ask the person's age and they say 90, and I ask the date of birth and they say 1970. Who's the president? No, it happens. Who's the president? The other problem we get with remote proceedings and people who may or may not be incapacitated, you don't know who's in the room with them. You don't know if they're being influenced or led and guided in their testimony, right? So 4 years ago during COVID, we're trying to do a remote trial on a will contest, and you had 3 brothers in the same room, and they only have one computer. So I'm like, you can all stay, but only one person's testifying, no coaching, no group testimony. And of course, you could hear a voice in the background, and I admonished the witness, and he said it was car noise, and I said, well, that car noise still sure has a low voice. But but sometimes it really does come down to things like the observations that you can make, and you have all this testimony, because it's not unusual for people to need medication reminders, to miss doctor's appointments. Yes, the high-end practices send you constant emails, and especially when you have a payment due, right? They won't let you out of the office, or before you go back to see the provider, they tell you, oh, by the way, you have a balance. But that's not what we see. But that's just the start of the capacity assessment. I know there are questions about navigating conflicts among the family, and the statute provides priority. Don't hold me to it because I'm not looking at it right now, but generally, so you look to the wishes of the subject, and it's spouse, a parent, and then child, and then you're like, well, what do you do when they're two children arguing? And I was like, well, usually in my experience, it's pretty easy why one gets priority over the other. But there are all kinds of different scenarios. So that's just a few things to give you a background on the capacity assessment, that it is very statute-based, and it's very methodical. And then you have to branch off that to all the different twists and turns of any particular given case. So, thank you.
Okay, our next presenter is Dr. Syretta James. Dr. James' presentation will focus on mechanisms to assess capacity, defining capacity through the lifespan, and how to engage subjects in the assessment process. Dr. James is a board-certified licensed psychologist, executive leader, educator, and mentor committed to reimagining how mental health is delivered across communities. As the executive director of business development at Respire Behavioral Health, she guides a thriving nonprofit group, practices operational and strategic vision of serving children, adults, and family in the metropolitan DC area. With a doctorate from Howard University, she specialized in certifications in trauma, early childhood mental health and forensic psychology. Dr. James' work lives at the intersection of science, social justice, and service. She's passionate about improving outcomes for system-involved and marginalized populations while shaping trauma-informed practices that are both compassionate and evidence-based. From publishing policy-relevant research and designing interdisciplinary interventions and programs for court or child welfare-involved families and individuals, her career reflects a deep commitment to leadership, learning, and legacy. Dr. James has trained attorneys, judges, clinicians, and emerging scholars with an eye towards impact, innovation, and outcomes. She recently accepted a 3-year appointment to the Anne Arundel County Adult Public Guardianship Review Board, a coveted role that will provide impartial oversight to those living under public guardianship. So please welcome Dr. James.
Good morning, everyone. Two things. I'm not as funny as Judge Ross, so it's really hard to come after him. Also, my first name is Syretta, even though I give Judge O'Keefe a pass because my parents did a terrible disservice by taking away one of the E's. So most people say Syretta, but my first name is Syretta James. The families I work with typically say Dr. J because I think they get all tongue-tied in the beginning and they end it with, I'm just cutting everything off. So you can call me whatever you like, but today I'm going to be here presenting as Syretta. I'm delighted to be here. I am a graduate of Howard University, so anytime I get to hang out in the District of Columbia, it is indeed my bison joy. I am also someone who always starts off my discussions in honor and grace of those who have invited me, so I'm going to do that today. I am so delighted to be here as a plenary member because I'm here to talk about the assessment of individuals who are the most vulnerable. I'd like to first thank the organizers of this wonderful session. Two people stand out tremendously to me because they're the people who kept me together, but I'm going to first thank the entire probate division. But more specifically, I want to give greetings and thank yous to Miss Aisha Ivy Nixon and Miss Tanya McNair, who has really worked throughout the weeks, months to bring you all a wonderful conference. I am sincerely gracious that you all decided to make me one of the presenters because you guys are bringing together a thoughtful group of professionals who work together to address the needs of our most vulnerable. I also want to thank the person who brought me to this work, and that's Dr. Barbara Tobias. I don't know if she's going to be here today. She's a remarkable evaluator who has, her entire career is steeped in capacity in forensic science. Lastly, I want to thank all of you for being here, just to listen to my big mouth, but it shows your commitment to serving those in the district. This guardianship process is one that is unique and complex and involves many individuals. And I also want to thank and acknowledge the most important people in this process. And those are the individuals and families that we serve through the probate court process. Whether you touch this work through the lens of legal advocate, a clinician, an evaluator, or caregiver, or just simply a concerned citizen, your voice is impactful and the work that you do matters. Together, we all work to build a guardianship system that is just, compassionate, and responsive to the needs who rely on it. Many of these individuals live with debilitating conditions that profoundly affect their ability to function independently and act on their own. They rely on evaluators just like me to answer the court's questions and establish a picture of who they are and how they are, functionally, intellectually, and socially. Now, many people believe psychologists have magical powers and we're able to predict and guide and do all these things that we are not able to do without a significant data source. And believe me, if I could predict, guide, I would be using that to, one, make the world a better place, and then two, to hit that billion-dollar lottery that I just missed. So psychologists don't have magical powers, but we are guided by science. And what I want you to know most reliably is that we do have a set of processes and procedures that are empirically derived to help us deliver the most sound decisions possible. In fact, one of my first supervisors, when I began this work, used to say to me that being a psychologist is much like being an artist. It combines the science and it combines all the unknown to paint a beautiful picture of how an individual functions. And then we shape that together. I think I lost my mic. There we go. And then we shape that together into a representation of what others use to make decisions about people's lives. So that's our work, unique and complex. For me as an evaluator, this process begins by gathering data that allows me to understand the historical underpinnings of how a person lived their lives. I take my analysis from birth through adulthood. So yes, I'm asking questions about what you can recall at 92 when you were a kid. And I identify their functional strengths and weaknesses throughout their lifespan. This information builds the foundation for how I assess their current abilities because it contextualizes the individual and it moves that person from being a simple subject who may present in my office, but many of whom I'm meeting at the bedside or in the community, to becoming more familiar so that I understand their interest, how they were actively involved in the community, how they established relationships, and more importantly, they were worthy of my understanding. Individuals who cross my path typically include those with neurodegenerative illnesses such as dementia, cognitive decline, vascular disease, developmental disabilities, and other chronic and severe mental illnesses like schizophrenia. However, the diagnosis and classification alone is not the focal point of my analysis or discussion. What concerns me most is how they are presenting now. That requires an analysis that prioritizes the individual's dignity, safety, and autonomy. I do this best by starting each of my evaluations with a spirit of knowing who I'm evaluating, hence that comprehensive background and as much as you can tell me about your childhood, early adulthood, and your now. And that history then allows me to utilize objective clinical tools that measure current functioning, disease progression, and it establishes a baseline of who that individual is in their current context. As a psychological examiner, I've spent many years supporting families, and my role in the probate process is guided by the principles laid out in the District of Columbia Guardianship Act that's been codified in Title 21, Chapter 20 of the DC Code. This legislation provides a framework for protecting individuals deemed legally incapacitated and unable to manage their personal or financial affairs. That's the underpinning. It emphasizes the importance of thorough, impartial evaluations and the need for guardians to act in the individual's best interest. Psychological examiners like myself do play a critical role in this process. We are tasked with conducting very, very difficult and complex evaluations that consider not only the intricacies of a person's current functioning, but also how that functioning connects to past behaviors and skills. The analysis required considers all aspects of a human condition and integrates information from medical, psychological, and social factors that may contribute to declines in an individual's functioning. These evaluations are not just clinical. They are profoundly human, and they consider an individual's strengths and weaknesses. As our previous speaker said, that's what she would like most evaluations to do, and they should. And perhaps they may even consider things that the individual is working on to improve now, because people do, even in their incapacitated state, have ideas, things that they want to do, and beliefs about themselves. Our findings most importantly, help inform the court's decision about capacity, and ensure that guardianship is pursued only when truly necessary. A little bit about my testing process. It involves integration of data from observations, interviews, record reviews, and objective analysis from clinical tools. And it terminates with a discussion about an individual's ability to access resources that could contribute to functional improvement or assist them in potentially regaining all or parts of their previous presentation. My conclusions always offer a statement about whether or not that individual has a mental or physical impairment. Notice I said nothing about a diagnosis. And then I summarize how the impairments impact the individual's functioning. Some examples of this, because I know you're all dying to see what's in my reports. They're really long, so could include discussion about how individuals' persistent confusion and difficulty with executive functionings, including sorting, planning, sequencing events or information, impairs their ability to receive and evaluate information effectively or communicate decisions effectively. As a final step, I identify the areas of limitations that are affected. Now, I know our previous presenter said we should be focusing on strengths. I do that throughout the summary of my document. These could include difficulty managing personal or intangible property, difficulty understanding benefits or manipulating their income, difficulty making and maintaining healthcare decisions, or difficulty following through with self-care routines, or simply preparing a meal or dressing independently. Whatever it is, I summarize that so that the court understands where the limitations lie. The goal here is to clarify for the court how the individual's functional needs are impacting who they are. This work cannot be done in isolation. Evaluations with these high stakes are inherently multidisciplinary, and they involve collaboration among legal professionals, social workers. I moonlight as a social worker, y'all. I really love their ecological framework. Psychologists don't necessarily live in that land. Medical providers and family members to provide the most accurate information and a reflective picture of the individual's functioning. Each individual's perspective along this process is valued, and it adds depth, understanding, and meaning to an evaluator's analysis, and it helps practitioners craft protective and empowering clinical conclusions. As we begin our discussions today, I hope to share insights from my experience. But more importantly, I hope to improve your understanding of the examiner's role. We do not have magical powers. We are but a piece of a complex process aimed at providing responsive, compassionate care for individuals who cannot make decisions for themselves many times. We rely on data collection, integrated analysis of information collected from various sources, and we do our best to provide a profile of the whole person who may be encumbered by a chronic disease or a mental health condition, but has a pattern of functional strengths and weaknesses that require our thorough review and analysis so that the recommendations offered provide them with as much dignity and autonomy as possible. On a personal note, I work each day to refine my approach so that the work I do is meaningful to those I serve. By studying outcomes, identifying gaps in my process, and listening to the lived experiences of those I have assessed and affected, I am better poised to make systemic change in my process when necessary, and also to consider the whole person. I endeavor to do that today for and with you, and I'm looking forward to sharing and in growing in this experience. And I bring to this role a special, special gift. My grandmother was affected by dementia long before I was actually a clinical psychologist, and it was my family who had to act on her regard. Unfortunately, her dementia did not allow her to live in place like she wanted to, but we made decisions for her with the greatest, with respect to her greatest amount of dignity. And one of the things she said to us before she could not remember our names, before she did not know where we were, and before she could not recognize us as family members, is that she was counting on us to ensure that she lived her last days as free as possible. So I do that, I bring that to this work, and I'm delighted to be here.
All right. I'd like to start off the question and answer session with a question to Judge Ross. Judge Ross, from a legal standpoint, what are the most critical pieces of information you need from a professional's capacity assessments to make a sound decision regarding guardianship?
I think I need to know what the subject can do and can't do. But I think at bottom, the lawyers get caught up in legalese. And sometimes it's just really practical things, right? If somebody, if they have no idea who their doctor is, when the last time they went to a doctor, where they do their banking, it's kind of a common sense that this is somebody who needs to be protected. And they may say, but look at the last physical. The person's blood pressure's fine, heart rate, so on and so forth. I'm like, yeah, physically, but they're not showing the capacity to manage their health care. They don't know when their last appointment was, when their next appointment is. They don't know where they bank, what bills they have to pay. Now, technology has mitigated some of that, right? Because when people start to age, if they have resources, but that's a big caveat because most of the population we serve is moderate to low income. You can automate their bill paying. You can use electronic monitoring now, cameras. It works for daycare.
Closer to the mic.
And it works for elderly people. But I think that's what's unfortunate is when, even though we have a lot of expert testimony, it comes down to evaluating the person day to day and being practical. And I think that's sometimes what I look at. You know, it's like, well, the person was supposed to be here in person, and he's not. And he's confused about where he is or what's going on. And so how's this person going to navigate life day to day? That tends to be one of the things I look at. And family members are, just one quick, family members are arguing like, we can do it. And I'm usually, they don't like it, but I'm usually like, well, if you can do it, then why are you here before me? Because you obviously couldn't get it done. No, you didn't, right? You didn't get it done. And then they go, now we're going to turn it around. And I'm shaking my head. It's like, you can't turn it around. And I will tell people, do you have children? How many? Do you have a job? So exactly when are you going to take care of the subject? I'm not really popular that way.
Are there particular common gaps or missing details that you feel you seek on a regular basis?
From our examiners and visitors?
And lawyers, anyone, just in general, in order to make a decision? Is there just a particular type of information you feel is always lacking? Or
I don't think it's always lacking. I think generally we have a high level from our examiners and our visitors and our fiduciary panel members. But, you know, we appoint counsel, we appoint GAL, and we're dealing with a challenged population. So there are some members of our panel who are hesitant to be decisive. What is your client's position? And they're like, my client gave me inconsistent answers. And so I'm like, where are you today? And They're like, ask my client. I'm like, so I think that there's a lot of human emotion and empathy and passion involved, but as professionals, the lawyers, the social workers, the visitors, the examiners, you have to make a recommendations. Judges, we have to make decisions. And you have to realize some of those decisions are painful, and you can't keep everyone happy. And you gotta be decisive. The way I look at it is once they come into the court, whether they're in the guardianship proceedings, juvenile proceedings, and neglect proceedings, years ago, mother was apologizing to me in the criminal court, and I was like, don't worry, he's my responsibility now. And that's what I look at. And I would ask people to want the same level of concern, care, and decision-making you would make for your own family or for yourself. And I think that's dangerous when people dissociate and they refer to the ward and the subject and their family as they, or, as a separate from realizing that they're human beings in the same community you are and deserve the same care, concern, comfort, and circumstances that you would want for yourself.
Okay. So, Dr. James, how do you approach the initial assessment for capacity, particularly when working with an individual with cognitive impairments like dementia or persistent and severe mental illness?
That's a good question, because I think what stands out to me is that I don't want folks to get married to diagnoses. What I do for my initial assessment is I let my data take me to whatever their diagnosis is going to be. And so initial evaluations are the most important evaluations, but I want to kind of give you one fundamental truth, that there's no one-size-fits-all approach to our evaluations. If you start seeing templated evaluations, you should be concerned. We should have some template, but it shouldn't, your report should reflect the person and not a particular scale. People come with a unique constellation of gifts, strengths, and weaknesses, and they are whole people. So what you should do is look for the description, at least initially, when that evaluation comes across your way, of who this person was prior to any diminished capacity. That comes from sources that we have to sometimes really dig deep to find: family members, people who may have known them, medical records. And so a good examiner is getting access to that and making sure that that information is integrated. Objective measures could be a part of your process. It's not a part of everyone's process, because people, again, come to us and they can't even speak. So what objective measure can I actually give that's not just observational? They don't like me, this mic today. It just keeps cutting me off. It may involve some objective analysis. It may not. But in the ones that I use, I love the independent living scale. It's a super, super old scale, but it kind of identifies all the functional areas of impairment that are most important in the evaluation. So financial, self-care, cognitive functioning, social functioning, the things that matter. And then it helps guide my questions as I'm interacting with the family members and the people who are involved. I always do a summary analysis of what the medical providers have provided me, particularly in the diagnosis that you mentioned, like dementia or cognitive limitations, because that is both a medical and a psychological thing. So if evaluators are not doing that, then I feel like they're not doing their due diligence to really kind of clarify what an individual has. And then I also, if there's a social worker involved or a case manager, I summarize who and what those I summarize the information of who that case manager has described this person to me to be, and how I see them functionally in the current context. The most important part, I think, of the evaluation is your recommendations and how you're classifying findings. And I said that in my early introduction, where I'm talking about where are the functional limitations and the strengths. I don't think I talk about that enough when I'm presenting this information. Obviously, I'm talking about what the person can do, but the courts often really want to know well, what is limited? So while there's a unique balance to that, I think we do that through all of the summary of information we do in the background. But your conclusions and your integrated text should also talk about, we're really delighted that subject X can wash their teeth, wash their face and brush their teeth independently. However, they're having a hard time recalling what needs to go on the toothbrush. They may have a difficult time recognizing that they have to pull their pants down when they go to the bathroom. All of these things help the court understand how they need to be supported. And so you're looking for that in the initial evaluation.
So what about in situations where you have somebody with intermittent, where they have mental illness, but it sort of, they decompensate intermittently. And so they're actually quite able to take care of their business for much of the time, but then they stop taking their medication, end up hospitalized, and the family comes rushing in trying to get guardianship.
Get support. And that's actually a common issue. And what I'd say is, what is intermittent? Because we're going to have data about this individual throughout lifespan once you've done that background. So if every 3 months this person is not taking their medicine, not following through, then they're not a person who's actionably following through with their care, and they're not able to maintain it because they're going to feel good for that brief period of time that they're medicated and followed. And oftentimes when they're doing it the most is when they're in the hospital, when people are watching them. It's when the eyes are off of them. So you are providing a picture of how this person performs over time. And contextually, you may meet that person at their most functional state. Actually, one of my favorite cases was someone who was like walking around DC naked and was talking. And then when I saw him, I'm like, dude, dresses good. He smells good. He was cleaned up. But then when I got the background, I saw that this was a level of decompensation that was progressive and had occurred over time, and that there was no ability for this person to regain that autonomy because over the past 5 years, he was very well known to the hospital that had identified him, very well known to the case managers, and all of them had the same kind of support is like when he's in hospitalization and when we're holding his hand, it's great. But after those supports fall away, that independence is not there, and there's not able to maintain that. So you're making decisions based on a picture that you're provided through all the available sources.
And Judge Ross, in a situation like that, where you have the person who comes in and says, I don't want a guardian, I don't need a guardian, I'm perfectly fine, and yet you have the family who wants to become the guardian so that they can take the measures to either force or encourage medication or hospitalize or keep the person hospitalized when they do have their mental health breaks. How do you deal with cases like that?
Well, I see it more in the drug context. The family wants to be a guardian to enroll someone in a drug program, and I tell them, even as a guardian, you can't, and they usually go away. The other issue I try to do is I try to convince people that, especially if they're eligible in the guardianship fund, that it's a benefit with no downside. And I try to analogize to them. And I tell them, you see me in court, but I have my very large supportive staff. My law clerk's here today. And my secretary is getting a performance award, so she's not here. And the courtroom clerk. And I'm like, this is what you're getting, and you're going to get it free on me and someone to help you. So that's the first thing I try, is to try to convince them. Now, the problem that I have with that is that usually the people who need it most are the most resistant because they can't rationalize. It becomes an ego thing. With people who have addiction and mental health struggles, there are good days and bad days. And generally, if they come and see the court and it's a bad day, we appoint the guardian. And the guardian should do his or her work as consistent with the needs of the ward. And so when the person is medicated and doing well, the guardian has to do less. When the person is off their meds and homeless, the guardian has to do more. In that regard, many times guardians come in to me and say, the person's homeless, I can't find them. I want to terminate the guardianship. And I say, no, we need the guardianship even more. And you have to spend 2 or 3 hours a month doing your due diligence to try to find this person, to try to get them sheltered, housed, and to get medical treatment. Sometimes it works, sometimes it doesn't. But generally, we have to do the evaluation from where the person is when they come into court. And Dr. James made a very good point. She doesn't do a diagnosis, because you could have someone who has schizophrenia, but that person takes his or her med and is high functioning. And on the other hand, we have lots of people who may not have a mental health diagnosis. It's usually age-related. They may have early onset dementia. There's also a socioeconomic component, right? Wealthy people with age-related dementia will put their affairs in order well in advance with a healthcare power of attorney, a financial power of attorney. They'll day programs and so on. But that's not the population we serve. Usually it's a lower income population, and we are behind the 8 ball. Action should have been taken 3 to 5 years earlier. I don't know if that was responsive to your question, but.
That was extra. That's good. What evidence is most compelling when a case comes before you for termination or modification of a guardianship?
Termination, usually the person's moved out of the jurisdiction and is no longer getting services. I think there have been 1 or 2 cases, and I see the DDS folks here, where basically they've done such a great job with people and they came into like a guardianship at like 18 or 19, but they continued to develop. So we have had people who evolve to the state where they can have independent living. They will, the facility will be their representative payee, but they learn to shop on their own, or they may just have a limited health care, someone for health care decisions. But it's the same thing. Before we terminate, we have to get a capacity assessment with a licensed examiner. But more likely, the people have left the jurisdiction is the most likely. So regaining capacity is very limited. But we do have protections, right? There's supposed to be a triennial review and a reevaluation of capacity in DC. But it's very rare. I mean, most people are incapacitated either because of disability or physical limitation that they were born with, or things get progressive, right? If people can't remember how to get dressed and they're aging, it's going to go downhill from there. But it has to be there has to be medical evidence the person's regained capacity. If not, it's a non-starter from there.
So, Dr. James, we're going to change up the subject a little bit. How do you assess capacity for individuals where either socioeconomic factors or cultural differences or language barriers may influence their decisions and potentially leading to misinterpretations of their competency?
That's another great question. You're doing good with these questions. So one thing I'm speaking directly to the evaluators right now and the examiners is like, you do need to be able to know when you can't do something. So I'm gonna start with that first, and then I'll say how all the resources I gather if I believe that, I can do something. So I think we need to assess what our level of cultural competence is and how much we know about individuals. In an area as diverse as the DMV, you are going to meet people that you just do not understand foundationally a lot about their cultures. And I'm going to bring up a case specifically where I had to refer out and get additional support. The family spoke Farsi. They actually lived in a community where everybody was very much similar to them. And so it was a very closed off community. So even getting access into the community was very, very difficult. I had never heard of Farsi as a language before, so I had to look it up and figure out how I could get interpretive services. And then once I came into the evaluation situation, I knew very quickly that this was not an evaluation that I should be a part of, and I should get someone who had more cultural knowledge. And the reason for that, it was the entire family was in the room supporting this individual as I was doing the evaluation, and I did not know that that was a cultural part of their process. I would have believed, because this is about capacity, they were there to support this person and they could not do it. And then once I called in additional resources, I've quickly understood that I don't understand this culture and I'm not the person who needs to be doing this evaluation, and passed this on to a colleague who was far more familiar. I use that as an example because we do this job for money. This is how we eat. So giving away your evaluations probably feels really intimidating. But there is a need for us to know what we know and what we don't know and when we need to call in more resources. So I use that as an example. But you're also going to be able to do some evaluations with the support of that multidisciplinary team. And I always start with, what do I already know and how I'm able to kind of understand this? Do I have tools that are translatable in languages that I may not speak? How can I get interpretive services? I work in multiple jurisdictions, and so I have some jurisdictions who have a lot of resources where I can just get a call list and have the interpreter sit there on the phone with me, and then I work in other jurisdictions where that's not necessarily the case. I'm always integrating, that sign is supposed to say something to me? 10 minutes, okay. I'm always integrating information from their family background, and when I don't know, I'm writing that in the report. So it's important to assess what you know and what you don't know, and make sure that you are not limiting folks because you are not aligned with their cultural background. Now, SES factors are often very difficult to understand. We know people living in traumatic conditions are functioning differently, and you need to be able to assess that through your interviews and observations, and you need to be able to ask questions that are trauma informed. There's no specific trauma developmental questionnaire, but there is one that has been put out by APA in their assessment for the aging handbook, where they talk about the types of questions that you can use to guide trauma-informed assessment. So if you don't have that, get that book. I believe it's actually online for free, and you can just pull that page out and use that as you're using your interviews and interviewing family members, anybody who's associated with the family, and then understand the culture and the context of which people are living. So you need to be able to understand the conditions. I work in multiple jurisdictions. Working in Queens County is very different than working in DC. And so I have made a point to understand what it looks like, what poverty really looks like in Queen Anne's County. It looks very different than in DC. And so I'm integrating those discussions into my report and in my analysis, and making sure that I'm being as supportive of the whole individual and not what my biases are. We all have them, right? We all have them. It's hard as examiners to know them. We have to make sure that we're checking them in our reports. And I'll say, this may be a part of this individual's cultural background. The court may need to assess this differently. So don't be afraid to write that in your evaluations when you simply do not know.
If I could just follow up on socioeconomic factors, I touched on this earlier. There's some things that cut across socioeconomic factors. And one thing that I found in this city is we have a large number of people who are highly educated, right? Every night there's someone from the DMV on Jeopardy. But we also have a high number of people with low literacy, right, who are only functioning at a third or fourth grade level. But what are some things that people have in common? What is your name? What is your age? What is your date of birth? Where do you live? And, you know, what day is it? What day, month, year? Those are things that cut across socioeconomic lines. And you'll be surprised that when I did juvenile, and I'd have a 12 or 13-year-old who would not remember his birthday and was fidgety and really wasn't sure of his age. We did the educational assessment, but I realized right there that there was probably a learning disability. And the same thing can happen in court, that when it can be really contentious and you have that person right there sitting in front of you. And those are basic questions, right? For those of you who are parents, when you have a 5 or 6-year-old, what's your address? You know, what's your mom or dad's phone number? Now the kids don't have to remember that because they say, oh, it's on my cell phone. But still, those are basic things that you can cut across socioeconomic lines and see that there's a problem.
I wanted to add, I'm glad that you mentioned the literacy rate. For evaluators, ensure you are using tools that are at the correct literacy rate. I think that's very important, and we often miss it. And most assessment tools are written about the 6th grade level, and what we know is that's way too high for many people in our areas. So if you're using tools and you're asking them to independently complete scales, then make sure you are going after those scales to understand what they knew and understood about that. And the test publishers tend to to publicize the reading rates on there. We're getting the cue to stop, so I'm gonna stop. But, I can't see you. You need to shout it like the person on the Sandman, pull us off the stage.
We've got a clock up here.
So I totally lost my train of thought. I'm having these senior moments. I don't know what I was saying, but that's.
Tools appropriate to the.
Yeah, tools appropriate to, and, I was saying the test publishers publish the reading rates. And too few examiners actually go to look at that. So you may find all of that information online before you purchase the tools that you use.
Okay, one last question. This may take more than 3 or 4 minutes, but family disputes are often at the center of a lot of these guardianship cases. How does, this is for both of you, how does the court navigate these high conflict situations to ensure the focus remains on the subject and in the best interest of the individual? And how does an assessor evaluate through all the noise of the family conflict what's, how to evaluate the needs of the individual as opposed to the wants of the family?
I'm going to Judge Ross go first because I'm curious.
As I said, there's a statute that gives priority, and most of you have had proceedings before me know that at the end of the day, the families matter at me than they are at themselves. Because I do push back that you guys have already dropped the ball. And there's usually some clear way, right? One family member has been accused of domestic abuse, financial exploitation. Where's Ms. Steiner-Smith? She can go through all those things that we see, but usually it becomes pretty clear to me that what the problem is with one or more persons. Or occasionally, I'll say, okay, we'll appoint this person to guardian. We're going to come back in 90 days and see how it's going. And there's already, 3 summary hearings. They didn't do the background check or something like that. And I'm pretty strict with that. It's like, you're going to do the job or I'm going to put someone else in. But that's how I usually do it, is that I'm hard on everybody. And I do that because I'm responsible. And so I'm like, here's what you have to do. And when we appoint someone a new guardian, the first thing that happens right there in court, we get their email, and my law clerk sends them an electronic copy of our 30-page book on how to be a guardian. And we send that right away, and we get their email. And I also tell all the family members, if there's any problem, just go to the clerk's office and file something, and you'll have a hearing before me. Also, we don't like it when people email us, but I will tell you a little insider secret. If an email comes to Chambers, I will look and see what's happening in the case. And we might tell people, it gets on my radar. Occasionally we've had to tell people just stop, but we only have a minute left. But it gets on my radar, and I will generally err on the side of just bringing everybody in and let them all vent for a while. But usually I end up being the focus of their frustration. But
Okay.
Since the Sandman's getting ready to come in a minute, I'm going to make this brief. The role of the evaluator is to be impartial. And so what that means is I'm going to be introduced to family conflict. What I try to do is not be a source of their conflict. So I'm hearing everybody out. I'm writing their descriptions. And I love that my role is not decision maker. I have to descriptively describe what I experienced, what the family is involved in, and hopefully those details are descriptive enough that the judge can make good decision about who are the most viable people in the families as a resource for the family. Now, if someone is downright hostile, I get out of there. I don't deal with hostility. And I don't think any evaluator should, but you'll meet people who are going to be hostile. So I think you need to have your own set of practices established, but recognizing our role is very different than the court's role. My role is to just inform. So the folks can download all they want within the 30 minutes that I give them of my time. And then I write descriptively how they have shared information with me.
And that's our time. We've run out of time. Thank you very much. I guess we have no time for questions.